Morning, Your Honor.
Good morning.
Good morning.
All right, sir. Are you ready to proceed?
Yes, Your Honor.
Would you like to take any time for rebuttal? 5 minutes is the max.
Yes, I'd like to reserve 5 minutes for rebuttal. Thank you.
All right, you will.
All right. Thank you, Your Honors. I'm Jonathan Sternberg, and I represent the appellant, Johnny Daniels. Mr. Daniels, as the court knows, appeals from a summary judgment in favor of the CSX Railroad on his negligence claim for damages under the Federal Employers Liability Act, or FELA, or FELA, as it's called. The trial court excluded his medical causation expert, Dr. Kenneth Spaeth, holding that Dr. Spaeth's testimony that his substantial exposure to the carcinogenic toxin trichloroethylene, or TCE as it's called, during his railroad work was a likely cause of his kidney cancer was inadmissible under the Daubert standard. And because Mr. Daniels then had no medical causation expert, the court granted the railroad summary judgment. Your Honors, as we point out in our briefs, excluding Dr. Spaeth and granting the railroad summary judgment was error. This court should reverse the trial court's judgment and remand this case for trial. The trial court fundamentally misapplied the liberal admission standards for expert testimony in Florida statutes 90.702 as interpreted in Daubert, which of course is based on Federal Rule of Evidence 702, which is what 90.702 comes from.
Mr. Sternberg,
yes, Your
when
Honor.
you say liberal standard of review, are you arguing that they have lowered the threshold of admissibility?
No, Your Honor. No, I'm not at all. When I say liberal standard of admission, I mean Daubert itself. Daubert.
Well, because the cases, even your Hines case and every case that you cite, clearly holds that whatever evidence, no matter how small, must be proven by scientifically reliable evidence. So I understand the lower standard, but the evidence is still subject to the rigors of the admissibility through Daubert. You would agree with that, right?
Absolutely, Your Honor. I certainly would. When I said liberal admission standards, I wasn't referring to the FELA. I was referring to Daubert itself. Daubert talks about it being, and Kumho Tire, which came after from the Supreme Court, talks about the Daubert standard being a liberal admission standard in favor of admissibility, in which exclusion is not the rule, it's the exception to the rules, the 11th Circuit puts it. That's what I was referring to. And Your Honor, when you are referring to the railroad's counterargument about the FELA does not change Daubert. We agree with that entirely. It's simply that, and the reason we include this in the brief, an exploration of the FELA standard, is, if this were a breach of contract case, saying that someone was medically injured obviously wouldn't fit the bill for expert testimony. Here, if, in a negligence case, saying that someone fit the FELA standard for cause wouldn't fit the bill either. But you're right, it has to have the rigors of scientific testimony, and I'd like to explore that with Your Honors.
If I may, Mr. Sternberg, maybe perhaps I could cut to the chase.
Sure.
The key issue here, as I read the judge's order, the judge came to the conclusion that basically your expert was relying on vague characterizations of exposure. And the case law basically requires that there has to be an identification of a threshold level of exposure that would cause or contribute to whatever condition that he's having now. So my question to you, your expert witness, and how do you pronounce it, Dr. Spaeth? Is that how you?
Spaeth.
Yeah. Okay. Show me where in the record did he testify as to what would be, did he identify a specific threshold level that your client was exposed to that would basically apply to the causation in this case? So help me out with that, sir. Sure.
A couple of things. First, Your Honor, Dr. Spaeth absolutely did testify to the amount of exposure that he believed Mr. Daniels had experienced. So Dr. Spaeth was relying on Mr. Daniels' own testimony, as well as Dr. Rosenfeld's report, which was never challenged or excluded in any way. And in Dr. Rosenfeld's report, he goes through having spoken with other people who worked with Mr. Daniels and had knowledge of what he had experienced to arrive at an idea of the sort of exposure he had suffered. And he says, since Mr. Daniels was able to, and if you want an exact record set, I can certainly provide that. Since Mr. Daniels was able to smell the trichloroethylene it would be about at least 28 parts per million. That's record on appeal, page 680. So there was an estimate of the amount that Mr. Daniels had experienced. However, Your Honor, I would take issue with your suggestion that case law says there has to be an identification of a specific threshold amount as well as an exposure to amount above that specific threshold level. The idea that there has to be an amount, like we have to say, well, exposure to more than 50 parts per million causes kidney cancer for trichloroethylene, and he experienced more than 50 parts per million. That's not the case. So that's certainly the railroad's argument. The problem, though, is on pages 45 to 48 of our brief, we discuss numerous cases from throughout the country, including here in Florida. And I point the court to the Northrop case from the 3rd District in 2017, where it's even where an expert doesn't know the specific level of exposure the plaintiff had suffered, where the expert reliably could testify he had suffered a substantial enough exposure to cause the condition, that's sufficient. And that, of course, was Dr. Spaeth's testimony here. Dr. Spaeth looked at the International Agency for the Research of Cancer and the Environmental Protection Agency, both of which have monographs, which a monograph is sort of a meta-study. It's a study of other studies, and it's a determination of whether there's a causation. And both the IARC and the EPA conclusively had said in their monographs that exposure to trichloroethylene causes kidney cancer. Now, Dr. Spaeth in his testimony explained that when you're dealing with a carcinogen like this, it's called a mutagen. And a mutagen increases in its efficacy the more that you're exposed to it. And here,
Mr. Sternberg, I think that goes to general causation.
it does.
But the 3rd, 5th, 6th, 8th, 10th, and 11th circuits all hold that there got to be specificity regarding the exposure to establish the levels of exposure hazardous to humans generally.
Mhm.
You've shown that, as well as the plaintiff's actual exposure to the defendant's toxic substance before he or she may recover.
Mhm.
So you're talking about smelling it, but according to Rosenfeld, who you would agree did not do a risk assessment as to TCE. He didn't. And he never opined that Mr. Daniels was exposed to excessive amounts of TCE. Actually, he said other solvents. So there's not just TCE involved in this case. Now, let's just set the record straight. No court should ever erroneously deny a plaintiff a right to a jury trial by excluding an expert. We understand this drastic remedy. But what we're looking at is a plethora of case law that says you've got to have the evidence of what amount is hazardous to humans. And then you got to have the testimony specific to the plaintiff that that hazardous level he was exposed to. So the IRAC, granted, they show an association to cancer. I read it, association to cancer. And a lot of studies they say are too small. They give an association. They do not give a threshold. Plus, there's a lot of case law about regulatory values. Can't be used as the sole causation evidence. Those are regulatory values because the expert needs to know how that agency came up with a safe level in the first place. So help me out with that. I mean, I know he's relying on the ARC, but then he quotes the EPA, which during his cross-examination, he says, yeah, I agree. The EPA does a lifetime of exposure, 70 years. Well, he worked for the railroad for 40, but he also worked and welded for 6 to 7 hours a day where there wasn't TCE being used. So help us.
Sure, Your Honor. And again, I appreciate that we're using these terms like threshold amount and amount of exposure, but the case law doesn't say this has to be a quantifiable amount. And it's not in every district, every circuit is that way. We point the court to a case from, you said the 8th Circuit, where I'm located, I'm in Kansas City, Missouri. The Bonner case and the Mattis case, both were about exposures by a worker to a substance. and didn't involve a finding that there had been an exact precise dose and an exact precise response, but it was enough.
Bonner's not a FELA case. She was a victim of a new toxic tort. There was evidence that it exceeded the safe levels.
Right.
We don't have evidence here that it exceeded the safe levels. Matter of fact, during cross-examination, Dr. Spaeth agreed that it was within the OSHA level.
And I appreciate that, but what he testified though is, and this is a lot more like Northrop, which is an asbestos case from Florida. And in Northrop, the expert was able to say that the long-standing exposure that the person had to asbestos was enough to cause the mesothelioma or other cancer that was at issue. The same is true here. So what he was able to, if you look at what the other folks testified, and I think it was your honor said it was other solvents, not just TCE. That's something that, so Mr. Daniels said, I don't know if it was TCE or not, but other people said, well, yeah, that same solvent that he's describing was TCE. So that's enough from which a jury could infer that the solvent to which he was exposed was TCE. And he testified that, or he said, and the other folks said to Dr. Rosenfeld that it was splashed on them, they could smell it. Mr. Daniels described one time when the skin was eaten off of his hands by this substance. I point the court to the Harbin case from the Seventh Circuit, which was a FELA case in 1990. In Harbin, there was very similar testimony about the exposure to soot and a plaintiff's testimony about how he was exposed to soot. And an expert wanted to testify, was excluded. This exclusion was reversed, that although he couldn't quantify the amount that this was, what the plaintiff was describing was enough to cause the cancer at issue. This isn't really any different. This is like Northrop or Harbin. Here,
but Harbin, he had a heart attack while cleaning a boiler wearing a mask in a sooty environment. He had immediate symptoms. Here, you would agree your client didn't have the immediate symptoms of the TCE exposure, which is, fatigue, irritation of the nostrils, things like that. Matter of fact, his testimony was he was around so much dust and paint that his nose leaked like a fountain. So
yes. And I submit that's not a whole lot different than saying I was exposed to such amount of this that it ate the skin off my hands. That I was able to smell this, and then that two other of his coworkers who were exposed to the same solvent also got kidney cancer. This is enough from which that can be inferred. Your Honor, what the alternative, if an expert being able to testify that here is the information I was provided, here is what I know about this substance, and the exposure that was at issue is substantial enough to have caused this. Isn't allowable, well, then what you really have is a time machine rule. And in the Westbury case, the Fourth Circuit spoke out against this. They said that only rarely are humans exposed to chemicals in a manner that permits a quantitative determination of adverse outcomes. Human exposure occurs most frequently in occupational settings where workers are exposed to industrial chemicals. And even under those circumstances, it's unusually difficult, if not impossible, to quantify the amount of exposure. You don't have to. As long as he can say, and they have their competing experts. This is in the Payne case from the 3rd District in 2022. They said, well, this is a battle of competing experts. It's something for a jury. So Dr. Spaeth looks at the exposures that there was evidence of. He looks at general causation and says this is something that can cause kidney cancer. And he says, look, this guy was exposed to above 28 parts per million for, as you point out, 40 years, certainly 20 years, that there's evidence of that they were using this TCE solvent degreaser at the Tampa yards, and says, based on my experience and expertise, based on my reading of the scientific literature, which are all reasonable, reliable methodologies that courts have done all the time, I can rule in, because that's what this comes down to, can he rule in the exposure to TCE as a possible cause of the cancer? If he can, then everything else falls away. And he can't.
Let me just kind of make 2 points if I can, is for Westbury, he had immediate acute symptoms, unrelenting science problems for which he was hospitalized, treated with antibiotics, underwent surgery. They still cited Mitchell, which requires proof of levels of exposure to humans generally and to the plaintiff, and he testified he was exposed to talc every day. Blew it off his desk every day. There's footprints through the talc. This was every day, 7, 8 hours a day, every day. Here we have evidence that your client was welding 6 to 7 hours a day, not around TCE. And then when Spaeth testifies in his deposition, he agrees that there's no evidence as to how much exposure from TCE causes cancer. It causes the kidney cancer. Then he testifies further down, a person must have experienced a dose of sufficient intensity, duration, and/or frequency to reasonably establish specific causation. Where does he fulfill that? How does his testimony, if the IRC is an agency that does a general study on those that are most affected and at risk, how does he then distill it down and narrow it down to Mr. Daniels for sufficient intensity, duration, and frequency?
Sure. Three responses to that. First, he's not relying on the IARC as an agency for like an OSHA thing, something like that. IARC is an international body that studies cancer and what causes it. He's simply relying for general causation on their monograph, which itself uses Bradford Hill to show that indeed in workers, exposure to TCE causes kidney cancer. Second, the evidence here was not as minimal, I think, as Your Honor suggested. It's pages 760 and 763 of the record in Dr. Rosenfeld's report that actually this was every single day, that Mr. Daniels had worked on recently washed equipment every day, that this was the same solution used to wash grease off cars and engines. While yes, he was welding inside and outside of solvent TCE washed cars. While he wasn't able to say that this was TCE, other workers could. I would submit that that's pretty strong evidence. And these degreasers were used in numerous operations all over the yards every day. And it was splashed on him when the cars were being washed, etc. That's a pretty significant exposure.
All right, you're at your 15 minutes. You can use it the way you want, your rebuttal time, but you're at 15 minutes. You can keep going.
Thank you, Your Honor. I believe I've sufficiently answered your question, and I'll see you on rebuttal.
Yes, sir.
Thank you.
Thank you. All right. Good morning, Mr. Turner.
Good morning, Your Honor. May it please the court. I mean, I think that some of the prime arguments made in the appellant's briefs have been done away with. There's no dual standard of review here. Clearly, this is an abuse of discretion case. The other point is that summary judgment, which an issue was made of that on the appellant in the appellant's briefing. The appellant conceded to summary judgment simply so this appeal could be taken. The summary judgment was not granted because of some FDLA analysis. It was granted because the appellant wanted summary judgment because without Dr. Spaeth's testimony, now excluded, the appellant could not carry a trial burden. So I think we dispensed with that. Summary judgment is not an issue here. They asked for it simply so the final order could be entered and we could be having this proceeding today. This is purely an abuse of discretion standard for Judge Peacock's ruling relative to Dr. Spaeth. And
Well, Mr. Turner, honestly, it seems when a judge reviews evidence, the admissibility thereof, and it's tied to a statute, certainly the rules of evidence, they're statutory. So there is kind of a mix. I mean, it is abuse of discretion, but we also have to determine whether it's legally admissible. So even though the feds and the state are all in unison as to abuse of discretion, I think we all would agree there's a little bit of both going on. So
I would say to the court, you know, unlike so many of the cases that are cited in the appellant's briefing in which exclusions of experts have been overturned, this was an extremely comprehensive hearing lasting portions of 3 days over a number of months. I think critically, the appellee's witnesses went first in this case, Doctors Lipworth and Shields, and testified to what a reliable methodology consists of in a case like this. And the appellant has conceded to that. In fact, the appellant has said, well, I think that, or Dr. Spaeth has said that he thinks his methodology tracks that of defense experts as well. There's really no conflict here about what a reliable methodology consists of. And Judge Peacock heard evidence for hours upon hours about that. One of the striking things about Dr. Spaeth's own testimony in the Daubert hearing is that he did not analyze for the court a specific paper. He talked collectively or in broad terms about things he said that he did. But after hearing the testimony of Drs. Lipworth and Shields, the appellee's experts, before laying out this withering and documented critique of the unreliability of Dr. Spaeth's methodology, he didn't answer that in this case.
And if I may, Mr. Turner, can I interrupt you? Because it's the same question that I asked Mr. Sternberg. And I'm looking actually the Mitchell case, the Mitchell versus Union Pacific, that seems to me that it really lays out beautifully what the issue is before us. And in that case, it basically, in a nutshell, they excluded the expert based on the fact that he failed to identify a threshold level of exposure, which would cause and contribute to, in that case, was lung cancer. So the same question as Mr. Sternberg, did Dr. Spaeth at any time testify or identified a threshold? And I realize what he said, the more exposure, the likelihood of getting the kidney cancer. But was there any testimony that he identified a threshold level of exposure?
No, Your Honor. All he ever did was say, well, if you can smell it, that must be 20 per million. His view is that any exposure above background, whatever that may mean, which frankly is not a medical term or truly an exposure term when it comes to disease causation. But his opinion, Dr. Spaeth's, is that any number above background increases the risk of any cancer. And so that's not helpful. It's not useful, because we also know through the testimony we're all exposed to the level of everything. That's what background is, that irrespective of where we live, we are around chemicals. He did not provide any kind of assessment about that. In fact, what he was saying was, and we went through the math with him on this, he was trying to say that given what the PEL is, the permissible exposure level set by OSHA of 100 parts per million, both then and now, and certainly during the period of the employment at issue here, that was the PEL for trichloroethylene. Dr. Spaeth is trying to say that anything above background levels, which he said were 0.03 parts per to 0.1 part per billion, is above background and therefore by definition has to be hazardous. There's no support for that. In fact, there's a long line of cases, particularly in the asbestos world, of the single fiber theory, or otherwise the any exposure theory. That's where he comes down. If he can make a claim that something is above background, then he feels that's all he needs to do. And that's certainly not supported by good science, and it's not supported by the law. Him saying in isolation, well, if he could smell it, that's 28 parts per million. Well, that's about a fourth of the PEL, if that's even true. I think the other point here, and it's been discussed, but...
And if I may, because I'm trying to anticipate what Mr. Sternberg may say. Well, now you're going into, isn't this more of a battle of the expert? It goes into not admissibility, but it goes to the actual, he could be cross-examined. It goes to credibility. It goes to the weight as opposed to admissibility. How would you respond to that?
You can only have a battle of the experts, Your Honor, if both experts have employed reliable scientific methodologies. Dr. Spaeth did not. And that was the entire point of the hearing and what was accomplished in that hearing. And it's exactly things like this. This opinion that anything above background is carcinogenic is not supported by good science. Judge Peacock heard that evidence.
Is there a study that supports that opinion? that anything above background level is hazardous.
No.
So it seems to me that all experts agree to the toxicity of TCE and that it can cause kidney cancer. So is there a study or peer-reviewed article that shows the extent of exposure to TCE that will increase the risk to kidney cancer?
No, not as the court has phrased it. And I say that the defense experts absolutely contest that trichloroethylene can cause kidney cancer. I mean, this is an open question that is subject to debate among those who have employed reliable methodologies. But in terms of a study that says, for example, if someone is exposed to 75 parts per million of TCE, they will develop cancer at this increased rate. No, Your Honor. There are studies that do include industrial hygiene sampling and try to differentiate between highly exposed people and those who are not exposed highly, but not as Your Honor has set it forth. What I also think on this point, Dr. Spaeth nullified the exposure evidence that he claimed he was relying on. You talked about, or it was spoken of, Dr. Rosenfeld. And Dr. Rosenfeld had no opinion formally expressed about TCE. And when it came to, this was really a welding fume case and a diesel case until those claims got abandoned on the eve of the Daubert hearing. And one of the things that's important about that is that Dr. Spaeth continues to hold the opinions to reasonable certainty. Welding fumes, diesel exhaust, and secondhand smoke cause kidney cancer and caused Mr. Daniels kidney cancer. They abandoned those claims, but he still holds the opinions. IARC does not hold those opinions. Dr. Spaeth only agrees with IARC, only defers to IARC if IARC agrees with him. That's not a methodology. Simply agreeing with somebody else and saying I did what they did is not a methodology, and that's proven in this hearing. He continued, in addition, to negate or nullify what Dr. Rosenfeld said about TCE exposure, which was that if it was used 1 or 2 days a week for an undefined period of time and sporadically after that. We know that Mr. Daniels never had symptoms of acute exposure, neurologic exposure, dizziness, lightheadedness. And yet, Dr. Spaeth turned that into the opinion that this gentleman had 20 to 40 years of injurious exposure to TCE. Judge Peacock heard this evidence and disregarded it because it's level. He's not accepted. He testified he relied on Rosenfeld. But if he did that, he couldn't support this excessive TCE exposure opinion. So he nullified it, expressed the opinion anyway. It's not.
Well, if they disagree or they conflict about Mr. Daniels' exposure, so we take Rosenfeld's conclusions and then we take Spaeth's conclusions about every day, which is different than Rosenfeld's findings, because there's no doubt he was welding 6 to 7 hours a day where there wasn't TC. But is that a conflict in the facts rather than the reliability?
It's directly to reliability. This inquiry doesn't mean anything. Somebody can just nullify the facts they say they're relying on. Judges is entitled to say that's not a reliable methodology. To say you're relying on an exposure expert and then ignore what that exposure expert says. That's the entire part of the methodology. This isn't like a competing set of facts where different people can select a view that's adequately supported by evidence. The evidence here, because Dr. Spaeth can't provide it, he's not the exposure expert, is what Rosenfeld said. But tellingly, Dr. Spaeth did say, I spoke with Mr. Daniels myself, and I concur. He worked 6 to 7 hours of every 8-hour day welding, not being around TCE. He conceded that he didn't have any other exposure opinions outside of what Dr. Rosenfeld had said. And yet, as the court pointed out, Dr. Rosenfeld never even did a risk analysis for TCE. Why? Because this was really a diesel welding case, right up until it wasn't. And IARC doesn't support causation with respect to diesel exhaust welding fumes, so they dropped it in an attempt on TCE where something different. And that's not a reliable methodology either. And Dr. Spaeth continues to hold these opinions despite is the weakness, the unreliability, the lack of support that the expert he's relying on provides him for exposure. And so this court, it is not an abuse of discretion for Judge Peacock to say, when you ignore your own experts and rely on things not in the record, there's nothing in the record to support Dr. Spaeth's conclusion that Mr. Daniels was around 20 to 40 years of injurious exposure, period. It's really impossible if he's welding 6 to 7 hours a day to say nothing else. But there's also evidence presented to him, or argued to him at least, that CSX, to the extent it used TCE, it never did after the mid-1980s. That didn't affect his opinion. TCE was a surgical anesthetic approved for use in the United States until the late 1970s. This was not some kind of material or chemical that should never, under circumstances, have been there. And so he took what he wanted, and if he couldn't find what he wanted, he just created it out of whole cloth. That's a methodology that's not reliable. That's what Judge Peacock was listening to. I'd also say this, it was interesting, when I brought up the abandoned exposures in the case, when I was cross-examining Dr. Spaeth, plaintiff objected. And Judge Peacock weighed in and said, no, this is important. I need to understand the methodology. I have to understand these issues. And this is all part of that. She directed us through these 3 days of the hearing, allowing every party to do whatever the party felt was necessary. She listened to everything. This is precisely what she was commanded to do by Daubert, and she did it thoroughly. The appellants don't even really identify where she got it wrong, much less abused her discretion. She didn't consider or weigh something over something else. She pierced through all that from what the opinions are to what the bases of the opinions are. And that's the reliability feature. Nothing about this hearing, nothing about Daubert has much to do about an opinion. It has to do with the methodology. And where Dr. Spaeth failed is that Daubert commands that experts show their work. In other words, how did you get there, the opinion, from here, the method? That's what we were challenged to do in this Daubert hearing. And what Judge Peacock determined, based on what she heard, that Dr. Spaeth didn't satisfy Daubert. It was unreliable at every turn, whether we're talking about exposure, talking about his consideration of the literature, talking about his utter inability to even provide evidence for how he arrived at the literature he actually looked at, how he weighted it. He didn't weight it. He didn't even talk about it with any kind of depth at the Daubert hearing. This was after he was challenged directly. He didn't provide Judge Peacock with a basis to determine that his methodology was reliable. And he had full opportunity to do that.
You're at your 15 minutes. I'll let you wrap it up, sir.
He's got 20.
Oh, I'm sorry. Just want to see if you were awake.
I'm still here.
I'm sorry.
One of the things we often hear is from plaintiffs is that it's not the correctness of the opinion. It's the methodology. Absolutely true. This is a case in which they're trying to insulate an opinion because it happens to agree with one that a majority of an IR panel agreed with. They don't actually want the methodology to be reviewed. And
here's my question. It goes back to something that Judge Sleet brought up, and that is the standard of review. I realize that the New Jersey Supreme Court recently went into some sort of discussion about what the standard, but it seems to me, generally speaking, to draw a parallel, this is much like a Fourth Amendment issue. We look for the facts, competent, substantial evidence to support the judge's factual findings. As Judge Sleet mentioned, whether or not this meets Daubert strikes me as a de novo examination, as a matter of law. Its admissibility might be an abuse of discretion because the judge has to decide whether it's relevant to the issues between the parties, and that is kind of on admissibility. But I think in terms of meeting Daubert, that strikes me as a de novo review. And I'm wondering, is that anything that we have to address? Seems to me analytically we do.
Yeah, I don't think so. I mean, the issue is the admissibility determination that the judge made under Daubert, which happens throughout. I don't.
Did the judge say it's not admissible because it doesn't meet the legal standard? It's not admissible because it's not relevant to an issue. It doesn't meet a legal standard. So to me, there may be a de novo aspect to the review based on the facts the trial court found. Was there competent evidence to sustain that? And then as a legal determination, Daubert requires this. You don't have it, therefore you fail. And since you fail in the legal standard, it cannot by definition be admissible as Daubert, as distinguished from it meets Daubert, it's scientific, but based on the pleadings, that's not relevant to any issue, which would be your tentative standard of abuse discretion. I don't know if I'm making myself clear, but that's my concern. Do we need to decide this based on a de novo? The law says Daubert requires A, the trial court found they didn't meet it. As a matter of law, you fail. And that's all we have to determine as a de novo. We don't have to get to any abusive discretion issue because we don't know what issue relevancy it would go into. It is only to prove a minimum legal requirement of admissibility.
Well,
I know they put me at odds with Supreme Courts all over the country, but I'm just, doing this. It strikes me we're passing on a legal standard.
Well, it's 9702. That's excluded under that Florida rule. That's abuse of discretion. I understand what the court's saying. So if we're talking about Daubert, then how did she misapply Daubert? She did precisely what I told her to do. She had the hearing.
Well, 9702 is our rule. Daubert may be the pattern on what it's done, and it's an interpretive device to determine what the law is. And the law was given to us by the legislature by 0.702. That is a legal standard for mission. The problems that they put in there, which are perhaps a codification of Daubert, but we are not determining on its face Daubert. We're determining on its face admissibility per Florida statute.
I don't see where any of the cases cited that related to Daubert in Florida said that because Daubert is an issue that we have a de novo review. What I would say, though, if you're, on what basis could the de novo review essentially that Judge Peacock conducted? She took evidence.
Well, I'm saying the standard review in this case may be, in terms of result, the same destination depending on which side we go on to. It's much like if you're putting a prima facie case civilly and the party moves for directed verdict, the judge looks for a legal standard and says, you have proved a prima facie legal case. You've met that standard. We go forward. Here, arguably, in comparison, the judge is saying there's a legal standard for admissibility. You didn't prove it. We don't go forward. That to me, that's my concern. It's not the argument. I'm just thinking maybe this language of abuse of discretion is the wrong language in its entirety, that there are subcomponents that we have to get through in terms of what we're really doing. Because if it's abuse of discretion, there's almost no review. What every reasonable judge would do, therefore, the judge is left to their own discretion, deciding whether it meets the legal requirements for admissibility. And that's not even the standard we deal with under the evidence code. You're bound by case law, what the evidence says, and you go from there. So I'm concerned that may be a misnomer, but that's not necessarily a preserved issue here.
All I would say to that the appellant provided the court with a series of cases in which judges were held to have abused their discretion. So it's not the end of the inquiry. And appellate courts have overturned those kinds of trial court findings in the past. None of those cases apply to this case for a host of reasons. But the idea that abuse of discretion is an insurmountable barrier, it hasn't been holding back Florida courts, and at least I think it's the 8 cases.
I'm not worried about it being insurmountable. I'm worrying about it being inconsistent.
Well,
for legal admissibility.
But isn't it, if I may, Mr. Turner, and following up what Judge Casanueva said, the bottom line here, we get to review what's before us, and we get to determine the order that was entered excluding that expert. Did Judge Peacock appropriately consider Dr. Spade's testimony, and based on what he testified to, she came to the conclusion that the methodology that he was using was really not an accepted standard based on what's before them, because his conclusion was more generalized as opposed to specific. So for us to review all of that and to come to a determination, did she appropriately exclude him under the Daubert standard? And this is what our job is right now, which then goes to what Judge Sleet was saying earlier. We need to go into Dr. Spates' testimony. What did he testify to? What did he rely on? Is the things that he relied on are accepted methodology as opposed to a battle of the experts? This is what we are tasked to do, as I understand the standard. Is that correct?
There's no battle of the experts here because he didn't employ a reliable methodology. But to the court's point, I think the obligation, we have a vast record here, which isn't always the case in these Daubert exclusions. And I do agree, it is the court's duty to go through to determine whether Judge Peacock abused her discretion based on this record in making the decisions and conclusions she did. I agree with that. That is what a reviewing court is compelled to do, but not to look at it and say, well, we need to weigh it in as a de novo review of what she's already looked at de novo. This is the evidence that was developed in her court. I believe the case law is very clear that while this reviewing court is doing it as Your Honor suggests, it is not to see, did she get it right? It's did she abuse her discretion in the conclusions that she drew based on the record?
Thank you. You're over your 20 minutes. I apologize for interrupting you. Had a brain cramp. Okay, Mr. Sternberg.
Yes.
5 minutes.
Thank you, Your Honor. I'll try to use them wisely. Let me start very briefly with the standard of review, Judge Casanueva. I'm glad you brought that up, and I think I can clear this up. It is abuse of discretion because an evidentiary issue is always about abuse of discretion. The issue, though, is if a trial judge or trial court uses the wrong or misapplies the relevant legal standard in exercising that discretion, then that is a question of law review de novo. And it's not true that Florida courts haven't held that before. In fact, this court, in a case Judge Sleet joined, you didn't write it, but Your Honor joined it, Barber in 2023, which was a Daubert case. It was a criminal case. But there's a discussion in Barber that where we're talking about the application of the legal standard in the exclusion of evidence under Daubert, that's reviewed de novo. And that's really what all our challenges come down to. You know, the alternative, the general abuse of discretion, is it arbitrary, fanciful, unreasonable? That's not the issue here. The issue is, I think, Your Honors have all pointed out, is does this meet the relevant legal standard? And let's talk about the relevant legal standard. My opponent just said that the question is whether he employed reliable scientific methodologies. I agree. That's ultimately what comes down, what this comes down to, because that's what Daubert and 90.702 are all about. Is it a reliable methodology? The problem is they aren't actually, and their experts aren't actually attacking the methodologies he used. They're saying that he misapplied or did not correctly apply those methodologies. What were those methodologies? Number one, it was a review of scientific literature based on his expertise. Northrop says that is a reliable methodology. In the state of Florida, it is well established that reviewing scientific literature and using one's own expertise is reliable. Beyond that, he used a differential diagnosis. That too is universally, Florida courts have held all the way back, the Florida Supreme Court held that several decades ago, that differential diagnosis to determine specific causation is a reliable methodology. What they and their experts are arguing is either the underpinning of his facts were insufficient for it, which I have addressed and will address, or that he misapplied these because he didn't look at the studies correctly, as Mr. Turner just suggested, that he cherry-picked IARC studies. Now, Dr. Spaeth had a response to that, which is, well, IARC says this specifically. There's no definitive study on these other things. What he didn't rule out necessarily. You don't have to rule out everything, especially in a FELA case where the only issue is whether the cause at issue played a part, no matter how small, in causing the injury. And I'll note he says that that there were these other potential causes, other potential exposures that we abandoned. It's true, that's exactly what we did, but it's not for the reasons he suggested. But the problem is that doesn't matter under the FELA, because even if some other exposures might have caused a part, under the Ayers case, we don't have to apportion the causes we don't have to apportion damages or fault between these causes. There only has to be, under McBride, evidence that the TCE exposure played a part, no matter how small, in bringing about his injury. As far as what the evidence was, Judge Kuzum, you mentioned the Mitchell case, which is from the Seventh Circuit a few years ago. The real problem in Mitchell isn't that there weren't quantifiable levels of exposure. The problem there was the experts weren't able to testify that there had been any amount of exposure to these substances at all, or say that there's some substantial amount that could cause this injury. It's not about quantification, and they want to make this about quantification. Here, the testimony was indeed pages 757 to 763 of the record, that Mr. Daniels was exposed to this every day. There was not a difference between Dr. Spaeth and Dr. Rosenfeld. Dr. Rosenfeld recounted that Mr. Daniels and his coworkers, even a welder like Mr. Daniels, was exposed to TCE every single day during his employment, which was 20 out of 40 years, at least, that they were using TCE. Dr. Spaeth was able to take that and say, this is a substantial exposure to TCE. And because TCE is a mutagen, and that the longer you're exposed to it, the more you're exposed to it, the risk of your cancer goes up. Just as in the Northrop case, which is exactly the same basic testimony that was held to be admissible expert testimony in Northrop in 2017, that is a substantial enough exposure to cause his kidney cancer. So therefore, I am ruling it in as a cause. Now, these are all our complaints about what Judge Peacock did, with all respect to her, was that these were legal errors. She said, first, he didn't have to state a dose necessary for TCE. Sorry, he didn't state a dose necessary for TCE to cause kidney cancer. The point is, he didn't have to say, this is the definitive dose above which this quantification, you get cancer if you're exposed to it. That is not the law, as we point out in our brief, and they don't really respond. She also said that he couldn't know the exact amount of his exposure. Well, that's not like Mitchell, because Mitchell, there was simply no evidence of what the exposures might have been. Here, he was able to quantify this. While their experts may disagree that the amount he said was enough, or that this mutagenic quality was enough, that's a battle of the experts. And that really is a factual contention, not a legal one. And finally—
All right, sir, you're at 5.5 minutes. I'll let you wrap up, sir.
Fair enough. The trial court misapplied the law in excluding Dr. Spaeth, and we asked the court to reverse and remand for trial.
Thank you very much. It's a very well argued case, and I would compliment you on your civility and professionalism throughout the litigation, and also agreeing to the statement of evidence. You wouldn't believe how hard it is for some parties to agree to a statement of evidence. But thank you, gentlemen.
Thank you, Your Honor.
Wish you a good day.
You too.
Thank you. Thank you both.